All right, we're going to go ahead and get started. Thank you all for being here this afternoon. We'll start with Senate Bill 42.
Thank you, Mr. Chairman.
Welcome, Senator.
Members of the committee. Today I'm bringing you Senate Bill 42. This is a bill that I'm carrying on behalf of the First Lady and the Governor. As you know, the First Lady's been a champion fighting against human trafficking in the state of Georgia. This is actually her 10th piece of legislation that she's been able to sponsor, and the work that she's been able to do has been huge. One issue that has come about recently is there is something in the law called the rule of lenity. And what that means is basically if you have two statutes that are similar and a defendant could be charged with either, the judge is to give basically the defendant the benefit of the lesser sentence, even though they may be the same charge, essentially. And with the human trafficking legislation that we've passed in previous sessions, the charge of human trafficking a minor has been found by at least two judges, one in Cobb and one in Cherokee, to be similar enough to the charge of pimping and pandering a minor to where they are starting to give the lesser sentence for pimping and pandering instead of the more harsh sentence for human trafficking a minor. And so what this does, it looks like it's doing away with pimping and pandering of a minor, but that's not what this is doing. What it's doing is it is doing away with it, but it's because all the elements of pimping and pandering a minor are encapsulated in human trafficking of a minor. So we're going to do away with that charge so that if someone is pimping and pandering a minor, that is sex trafficking. And that's what that's the message we're going to send, and the penalties are much harsher for that. And so it's really all the bill does. It cleans up the vagueness or the confusion with those two statutes, and will just allow prosecutors moving forward and judges to sentence those that human traffic a minor with human trafficking.
Great. I appreciate First Lady's hard work on human trafficking. It's an awful thing. Do we have any questions from members of the committee? Do we have anyone signed up to speak to it? I don't think so. Nope. Anyone out there signed up to speak to this?
If y'all don't have any questions, it's based on the 2019 change to the law, and it's a truly clean up bill.
Okay. Do you have a question? Now's the right time.
Move to pass. Second.
All right, we have a motion and a second. Any discussion? All in favor say aye. Aye. Any opposed? Congratulations.
Thank you very much.
Thank you. All right. Senator Albers, Senate Bill 27. And I think for today, this one's just going to be a hearing only. We'll move it to subcommittee. It can go to full committee without a passage here.
Okay, great. Well, thank you, Mr. Chairman, members of the committee. Appreciate the opportunity to bring before you Senate Bill 27, which is the Georgia Anti-Doxing Act. Just a quick note, if you're not familiar with the word doxing. Doxing is when a person intentionally posts someone's personal identifiable information without their consent online, and typically they'll say, hey, this is a terrible person, and here's their location, and they are right here right now, you should go after them, etc. And this causes people significant harm, both mentally as well as physically. It's literally an online version of stalking is the best way I guess I could describe this. Now, this isn't just me saying, hey, this is my good friend Deborah Silcox, and it's a picture of us at the Georgia Capitol. This is somebody who's actually doing something very nefarious, and in our online world, unfortunately, this has become pervasive. We've seen it from individuals, we've seen it from moms and young girls to folks who serve in office, to celebrities, and everybody in between. So it's very indiscriminate who it's gone after. And once this bill creates in Section 2.1 defines doxing, it creates a penalty for that, somebody to be guilty up to a misdemeanor, and then for aggravating doxing, which is with the intent to cause death or bodily injury, then that goes to being guilty of a felony. I want you to know, Mr. Chairman and committee members, we worked very closely. Our former Attorney General, our good friend Sam Owens, who is behind me here, we work with all the interested parties, and this could be the first time in my 15 years that my friends of Gacto and I are okay. They're not giving me a thumbs down, which is positive. They're not giving me a thumbs up, but they're not giving me a thumbs down.
I have similar challenges occasionally.
Yeah,
with that,
okay.
so I understand.
So that by itself ought to be pretty fantastic. But it is pretty straightforward. One of the things that was brought up in the process, though, and I think this is always a legitimate concern, is people always concerned about their First Amendment rights. So we very specifically on line 73 talk about how this is no way limits or restricts freedom of speech. And it just goes through, I won't read word for what it says there, but I believe we have checked all the appropriate boxes to protect people, as well as protecting, of course, their First Amendment rights. With that, I'd yield for any questions.
Thank you for that presentation. Representative Kendrick.
Going back to your discussion about the First Amendment, and I think we've had some discussions about, legislators and hiding their information from like tax records. If somebody posted one of our like personal addresses, is that going to be protected under sort of First Amendment speech, or is that going to be a question for the courts?
Well, I think the bill that's currently going through the General Assembly, as I understand it, would be able to, if passed and signed into law, would then get to conceal that type of personal information. That is not concealed today, though, so long as it is not, and for most of us it's online through either the state ethics website or somewhere else we've signed up. That information is probably done there. But if somebody did this maliciously, said, hey, John Albers, this is his address, and we don't like him because, he supports or doesn't support speed zone cameras in school zones, you should go to his house and start throwing rocks at it. Well, that's doxing.
Okay.
So.
Yep. Any other questions from the committee? Don't have any. Let's see if we have anyone to speak to it. Sorry?
Andrew Fleischman.
Yep. Andrew?
Thank you.
Sure, come on up.
Thank you. Everybody likes this bill but me. So, I know this is dealing with a real problem, which is that judges and legislators and people in public service are getting threatened online, and they're leaving public service or they're feeling unsafe. And I know it's a problem because my house was swatted 2 years ago by somebody who was mad because I had a Jewish last name. The problem is that this law does, in my opinion, have serious First Amendment problems, and it also doesn't really fix the issue. So, to start with, when we're looking at a law and whether it's constitutional, there's like a First Amendment flowchart we do. The first question we ask is, does it affect speech at all? And this does. It affects whether or not you can say something. And then we ask, is it content neutral? So, to give an example of a content neutral law, you could say no picketing at the Capitol. That's totally fine. That's a time, place, and manner restriction. But let's say instead you said no picketing except for labor unions. Okay, that's no longer a neutral time, place, and manner restriction. Now you care about the content of the speech, and it has to survive strict scrutiny. Okay, this law is a content-based restriction on speech because it forbids you from using my name without my consent in a way that could cause me economic harm. All you have to do is act with reckless disregard for the possibility that it could cost me $500. That's my understanding of the statute. And that's a very low intent bar. That's basically negligence. Okay? And that covers hundreds of communications that average people make every single day of their lives. If you go to the Golden Corral and you say Cindy at the Golden Corral was a terrible waitress, well, okay, you've given personally identifying information under the statute. That's her name. Or even if it could lead to her, that's her name. Could it cause her mental anguish, or could it cause her economic harm? It could. She could get fired for her job for that. Okay, this is an unbelievably broad statute. And while anti-doxing statutes are laudable, they have been struck down by the U.S. Supreme Court and the Supreme Court of Georgia. So, I've got here on this packet, Cox Broadcasting Corp v. Cohn, which dealt with the publication of a rape victim's name on a broadcast in Georgia. We created a civil right of action against such broadcasts. And the U.S. Supreme Court said, no, you cannot bar that. statement. Similarly, in the Florida Star v. BJF, newspaper published a rape victim's name. There was a civil cause of action. The U.S. Supreme Court stuck that down. So even if it's as narrow as do not publish a rape victim's name, that got struck down. Okay? And in Macon Telegraph Publishing Company v. Tatum from the Supreme Court of Georgia in 1993, similarly, a woman was accused of murdering a man who was trying to rape her. Her name was published. She tried to sue, saying, hey, I'm a rape victim. You can't publish my name. And the Supreme Court of Georgia struck that law down in that context. So when you've got a law that is based on content, what you have to decide then is it in one of a small category of speech that was unprotected at the time of the founding? Examples are defamation, incitement, true threats, fighting words. Okay, these are all well set out, and there's a case called United States v. Stevens that sets them all out for you. That was a case that held that, for instance, videos showing a woman crushing a kitten with a high heel are not in a special unprotected category of speech. That if you ban them, you have to satisfy strict scrutiny. Okay, that's how broadly, and I don't think there's any value in ladies crushing kittens, but that is how broadly the U.S. Supreme Court reads that right. Okay, so this law has a First Amendment savings clause, but that First Amendment savings clause actually makes things worse, right? Because if you were trying to make the law bulletproof, you would say, we are limiting this to true threats and to incitement. True threats meaning something I say that I think is likely to cause you alarm, okay? Or incitement. I'm asking for imminent violence against you right now. Go get that guy, okay? But the law says, hey, this protects First Amendment protected speech, but then it has an exception. Sorry. The speech or conduct including but not limited to true threats or expressive activity directed to provoke and likely to produce imminent lawless actions. So the savings clause specifically says we are not limiting ourselves to those little categories under Stevens. We're going a little bit beyond that. And I am not saying that there is like a ton of value in putting people's addresses out there. There's not. It's just not in a special unprotected category of speech. If you want it to survive, what you probably need to do is put it in something like integral to criminal conduct, which is something like, okay, if I offer a hooker $10, that is speech in a sense, but it's integral to a crime, and so you could go ahead and convict on that basis. Okay, so this is not in any of the special unprotected categories of speech, which means we apply strict scrutiny. What does strict scrutiny mean? It means that we have to make sure that the law is narrowly tailored to a compelling interest. Now, I think that this is a compelling interest. The safety of public officials in their home, that's compelling. The ability to judges to keep doing their job without worrying somebody's going to, like, swat them, yes, compelling. Is it narrowly tailored? No, because it's significantly under-inclusive, okay? I could buy a billboard and put y'all's addresses on it under this law. And in that J.B. Starr case out of Florida, they said because it only prohibited newspapers from publishing stuff, but not ordinary people, it's under-inclusive, it doesn't serve its purpose. But it's also overbroad because so many statements made online every single day could qualify. I put my real name on Twitter every day, and I post dumb stuff all the time. But if you say Andrew Fleischman is dumb, okay, well, did I consent for you to use that? Could that cause me economic harm? That is all that's required. I think what this law is meant to get at is something important, which is something like posting somebody's address in an effort to intimidate them or to cause them harm. Like, that's a real crime, and I think that's narrowly tailored enough that you could probably let it survive. But in an effort to swat the fly, you're using like a hand grenade, and you're hitting all kinds of other speech, both because the intent requirement is so low and because the possibility of economic harm is such a low standard. So I think the goal here is laudable. I totally understand why people want to do it, but I think under existing case law, this would likely be struck down under a declaratory judgment action, or individual cases would be held void as applied. Finally, I want to point out that this state has crazy private warrant hearings. You know, we had one just the other day about someone trying to bust into the Capitol building, right? And anybody can go seek a warrant, and then we just leave it to magistrates to know what's going on. And not all magistrates are First Amendment experts. So what you will see under this bill is husbands and wives, you know, exes, complaining about each other and going here to this law because they couldn't win a defamation lawsuit. You're going to see people misusing this law, and you're going to have to see people having to hire lawyers to deal with it. And in a way, this is not so much a prohibition on doxing as on criticism. You know, back when our country was founded, before it was founded, I should say, truth was not a defense to libel. In fact, there was a famous case in 1735, a guy named Peter Zenger, he was a German immigrant, came here, and he said the governor of New York was corrupt, which he was. He was unbelievably corrupt. Truth was not a defense. But those 12 jurors acquitted him. They nullified, and they set the seed for what speech would be in America, a place where truth is always a defense. And in our state constitution, under libel, truth is always a defense. But under this law, valid criticism that uses somebody's name, that gives information about them, even talks about their sexual orientation, can be banned, and truth should be a defense. And for that reason, I would ask that this law not be passed. Thank you.
And hang on real fast, just so tell me your name and it's Andrew. Tell me your name and who you represent. Or
I'm Andrew Fleischman. I'm just a guy.
okay. Good enough. Yeah,
I'm a lawyer.
Okay.
That's a great intro.
All right.
Thank you.
Yes, I think you have some questions, so hold on tight for me. Representative Holly? Is that you? Okay.
Kendrick was first. No, go ahead.
Either way.
Okay, all right. Thank you for the concern and the bill being brought, as well as thank you for probably the most humble intro I've ever heard of being up here, Mr. Fleischman. I was struck by something that you said, that literally, is it because of the law of this here that, for example, that you use, that our public addresses could be put on a billboard, that literally because it will require, in order for this to be effective, it will require that strict scrutiny, but because it can't do that, then therefore it's hitting too broadly, like literally we're all affected by this.
Yeah, if you have a law like this, you want to make sure you're hitting sort of like all the bad conduct, and you're not hitting a bunch of good conduct. You can hit some good conduct, but it can't be, what's the word I'm looking for? It can't be broad compared to the legitimate interests of the law. So, because there's still ways, like for instance, I don't know, if I'm a crazy person, I could go hand out y'all's addresses out front, flyers. I could say, these guys were really mean to me at this hearing. And that would be okay under this, because only electronic dissemination is disallowed. Well, that's an underqualification problem. That's a JB v. Florida Star problem.
Wow.
Representative Kendrick?
Yes, thank you. So the examples that you gave, I'm looking at line 46 that says that you commit the offense of doxing with reckless disregard, and then it goes on to complete the rest of that sentence. Wouldn't that solve, like in your example, like, you know, Darshan Kendrick is an idiot. Okay, well, that might be just your opinion, but you would also have to have the elements of reckless disregard to whether the information would do the rest of the thing. So doesn't it take care of your concern?
Reckless disregard is a pretty low intent standard. So, like, intent in criminal law usually goes something like negligence, criminal negligence, knowing, intentional, willful. Willful is like, I know I'm breaking the law and I'm going to do it anyway. Intentional is, I want to hurt you and that's the result I'm seeking for. Reckless disregard is, I said she was an idiot and it might hurt her business. I'm aware of that possibility. I don't really care either way what happens.
But I'm not challenging the sort of what the standard is. I'm challenging that there is a standard. And so shouldn't it take care of somebody's free speech to say something? Because you still have to prove that there was some element, some standard of which they're trying to harm the person.
When I criticize someone online, I know that it's a possibility that it might cause them some mental anguish or that they might lose $500. I know that's a possibility. I'm saying it right now. Like, how do you go ahead and defend against that? You have to say, well, when I said that this person was bad at their job, I didn't know that it was possible that it could cause some economic harm. The reason you said it, the reason you left me a bad Yelp review, and you say Andrew Fleischman is the worst lawyer I've ever had, is you wanted people to know I was bad at my job, and you were hoping that it would have an effect. So, I don't think reckless disregard is a high enough standard. If you made it willful, it would be better. Willful would be, I know this is against the law and I'm doing it anyway, but still, this is the sort of speech that's really hard to hit at. And I only prepped this morning. I didn't have time to get all the case law that I would like to get to, but there's a federal cyberstalking law that has a lot of as-applied challenges that succeed, where people say stuff about judges like, I don't like my judge, I think he's a tyrant, yada, yada, yada. And courts have been like, that's permitted. So, if you just said it at a reckless disregard, I don't think that provides a meaningful defense under the law. What would be really the meaningful defense is what I said was First Amendment protected. But that relies so much on the magistrate and on the prosecutor being experts on First Amendment law. And in my experience, most judges don't do a lot with it and aren't super comfortable with it. That savings clause is really for people who have good lawyers, and most people don't.
Okay, thank you.
Chairman, is it possible for me to say something?
Hold on one second. Yep, sorry. Representative Hahn? Oh, I'm sorry, Silcox. Yep, there you go, sorry.
Thank you, Mr. Chairman. Andrew, you had said that we had to have a compelling interest with a narrowly tailored component with it. And I appreciate that, and I appreciate the First Amendment. But I also appreciate Senator Albert's desire, because I do think this is a very important policy concern, particularly for elected officials. So with that in mind, would it be possible to put a higher willful standard and make it an integral part of a crime, like you said? Would it be possible to make this part of the swatting statute, for example, and make the standard willful, and make it a crime that way instead of this way?
You know, it's hard to say because I haven't found an analogous statute that's held up. Oregon has an anti-doxing statute that's still on the books. That's been, as applied, cut down in a couple of spots. I would look to that, and
Okay.
if y'all want some homework, I would be glad to send you some doxing laws that I think have survived scrutiny, so that you could take a look, because it's not impossible, and I think courts want to go with you. You obviously want to do something important. But when I was swatted, for instance,
Yes.
it was a dude from Romania, and I was making fun of white supremacists. And I said, white supremacists aren't afraid of being doxxed because their lives are going great and it will derail it. They're afraid of being doxxed because you're going to find that they live with their moms. This guy from Romania got so upset. He's the same guy who swatted Fonnie Willis and a bunch of elected officials here for free.
Me, twice.
Oh, thank you.
Yeah.
Christmas Day, the only reason I was spared is my son opened the door, who's 3 at the time. He was so excited to see the police. He opened the door for them, and obviously I hadn't killed my family. But this law wouldn't stop him.
Yeah.
Because he didn't find out my address because somebody posted it online. He found it out just because it's easy for people to do. And it wouldn't protect me, and it wouldn't protect any of us. That's so sad. And I wish we had a solution for it. I'm just not sure this does it.
Please send me the Oregon law,
I will.
because I would love to help Senator Albers pass this.
Okay.
Thank you.
And I have a question too. It's related to these threats don't have to be made inside the state of Georgia, right? So I'm not sure which one of you would be better to answer. But if it's not made inside of Georgia from a selection form, would it need a selection form clause?
Well, there's a personal jurisdiction issue there. You typically need purposeful availment of the state's laws to be held liable. You got to get in there somehow. It's in speech context, it's really tricky. Defamation cases can happen in all kinds of places. I'm honestly not sure about that. I was thinking about it coming in, but that's another thing. Someone could fight extradition, and if this applies nationwide, then you won't just have challenges from me, because I'll probably file something, but from, if Lauren Boebert wants to say something negative about somebody here and a bunch of crazy people respond, can she be charged? I mean, I can imagine this expanding in ways that are unforeseen and unfortunate.
Okay. Another question. Is this for the witness or the? I'm sorry.
Mr. Flashman.
Okay.
Thank you.
Good.
Okay. Really, thank you for being here. Really. I think because you understand the spirit of the Senator's bill and how we as elected officials, that we would like to protect our own loved ones, right? And I think, which is what I believe this bill is intending to do. The tough part is like you're saying, in terms of just that the brush may be too broad of a spread. Assuming the likelihood, even though I know that here in this committee, that serves a very good place for collaboration with those in the legal community in order to make the bills even stronger. If you see that a likelihood that if the committee would choose to pass the bill as is in defense of our communities, and would you see that the result of this would be maybe an incredibly litigious society going after basically trying to find fault with the bill and its misapplications in the public?
I mean, yeah, I think that would happen. And I mean, it's very hard to strike a law down for overbreadth, which is like when you strike down a whole law. So I don't think that would happen. I think what you'd have lots of little cases where the court would say, well, this is First Amendment protected, so you can't do that. And then we'd sort of have to understand the law by finding all the times it didn't apply. But I think that's bad because people aren't legal scholars, and they shouldn't have to check the cases to know what they can say. When I think about what's really bad, I think about someone being like, Andrew Fleischman lives at 123 Fake Street, go get him. And I feel like that's what we want to narrowly target, and this hits other stuff.
Great. Any other questions for the witness? Thank you. Thank you for your time.
Mr. Chairman, if I could bring General Owens up with me, and I just want to address a couple things, if I could.
Yep, absolutely.
I don't want to say that Andrew's wrong, but he's not really right. A couple things that I think are important to note.
Sorry, will you sit right here for me? Yeah.
A couple of important things to note. It's very, very clear, starting on lines 44, what the offense of doxing is, of intentionally posting personally identifiable information, which is outlined in the bill. If you go back, starting on lines 21, that talk about its person's identity, residence, location, social security number, alias, mother's maiden, I mean, all the stuff that is called PII, personally identifiable information. It also talks about this offense being fear of stalking, serious bodily injury, suffering significant economic injury, mental anguish, etc. This is very, very tightly tailored. There was a version of this that was not. This was actually tightened down for those very reasons. And I don't think, candidly, the language for the First Amendment could be any more clear. That began on line 72. And if you look specifically toward the end of that subsection on line 76, where it says, express activity directed to provoke and likely to produce imminent lawless actions shall be prohibited, which really goes counter to what Andrew was saying. So while I appreciate his background and his citing of history, I really don't think that applies candidly at all to most of this bill. I was swatted twice on Christmas and the day after Christmas as well, but this is not a swatting bill either. And it's not about elected officials, nor is it about celebrities or anyone else. It's about everybody. This is happening to people, unfortunately, more regularly. Important to note, this is actually the language in bill I work with Senator Sonia Halpern on. She actually carried this bill in the Senate last year, and I'm carrying it this year, so we've been working hand in hand. But honestly, with the exception of Andrew, we've had everybody support the bill. So, sorry, Andrew. Well, you guys don't.
Mr. Owens?
Thank you, Chairman. Just as Senator Albers stated and Representative Kendrick stated, the language on 46, et cetera, is very specific. It is not ambiguous. It is not vague. It is not overbroad. And while the prior gentleman gave you several cases from whatever courts on civil actions, this is a criminal-only statute. And it is entirely based on Counterman versus Colorado, which is a U.S. Supreme Court decision from 2023. The language in the bill intentionally comes from Counterman versus Colorado. So all of the discussion, the one case I was waiting for him to frankly reference is Counterman versus Colorado, because that's the one that's on point. And we're literally using the language from the United States Supreme Court.
Great. Any
Thank you.
questions for Mr. Owens? Go ahead and say who you represent as well.
I'm Sam Owens. I represent the Anti-Defamation League.
Thank you. Okay. Any questions for the witness? Thank you for your time.
Thank you.
Thank you.
All right. Is that for the witness? Okay. All right. Any other questions for Senator Albers? We'll see any. We appreciate your time.
Thank you, Mr. Chairman. Thank you, committee members.
Thank you so much. All right. Go 132 next.
That makes sense.
Yep. Senator Strickland, come on. We'll start with 132 if you're good with that.
Yes, sir. Thank you, Mr. Chairman. Members of the committee, I'm working off of LC 492340S. We had a couple other changes. There was one cleanup change from the Senate bill originally that I'm offering today in the substitute, but that comes from DBHDD. And then second, you're going to hear from Gactel. I've been working with them on a potential amendment that we'll put in front of you as well today. This bill is dealing with the issue of the process that we currently follow for someone that has their competency to face criminal charges questioned. And so I do not practice in criminal law, so maybe it even comes better here in more of a layman's way of looking at this. But someone questions, whether it be the defendant themselves, whether it be their lawyer or the prosecutor or the judge or whoever else sees this individual, questions early on once they've been charged with a crime, whether they're competent enough to even face the charges, whether they can work with their attorney, provide a defense. When that issue is raised, at that point, you have DBHDD coming in when a judge orders an individual to them to be evaluated. Evaluation comes back and offers one of three things. Either they're not competent and they can't be restored, they are competent, or they're not competent but they can be restored within a certain period of time. If you get under option 3, is the way I presented it, then you would go back and through a process of restoration. And what we've seen throughout in this process currently is you have a big backlog waiting for hospital beds, waiting for initial evaluations, and you are seeing and some individuals sitting in jail or you being released, waiting longer to face their charges than they would if they had just pled guilty for the charges. And so this is not completely fixing that, but we're building some additional due process protections in with this bill, but we're also treating nonviolent misdemeanors that we define differently to try to speed the process up for those cases and have an end for those cases if we have a point where someone cannot be restored in time where a case can be dismissed. So walking through the bill itself, this bill comes from the Advisory Committee on Forensic Competency, which is from our Behavioral Health and Innovation and Reform, I think I said it backwards, commission, our mental health commission that I never can remember all the right words for. We made it way too long to pronounce. Chaired by Judge Gosselin and also Herb Cranford, who is a DA out in Coweta Circuit, who I think's in the room. I saw when I came in. Back here. And so he may want to weigh in as well. But it comes from their committee and directly from DBHDD that they've worked with as well on this. Looking at section, well, let's go by page number. Page 2. The beginning here is that what I call the due process part, but it's also kind of a gatekeeping part where initially when someone's competency is questioned, you have a hearing that is had by the judge to make sure that we should put them into that system that I talked about of being evaluated. That's where I'll flag for you. We had some discussion on the Senate side. It was kind of late in the game. We agreed to look at it again on the House side where, with the hearing requirement, what's the role of the prosecutor in that? Is there certain, privileged information that could come out at a hearing initially? This is an early phase before any plea's been entered in a case. And so I have some language we're going to offer to you as potential cleanup on that part. Looking at, you see more of the same in Section 2. We have some cleanup and additional the hearing requirement built into Section 2. Moving to Section 4, we're moving up the time period from 90 days to 45 days for the initial evaluation for the nonviolent misdemeanors. Again, trying to speed up those cases that are not the case where someone's facing a lengthier
page
sentence.
4, right?
Page 4, yes, sir.
Yeah.
And I'm now working off my old draft, and it's still going to be page 4. Looking at page 5, and I can slow down so if you want me to, Mr. Chairman. Page 5 is where you get into after you've been determined to not be competent, but you can be restored. Current law says there is a 9-month period where court has jurisdiction over somebody, and you have we're moving that period from 9 months to 120 days for restoration for nonviolent misdemeanors. So changing that from 9 months to 120 days for nonviolent misdemeanors. And you see on page 6, if after that 120-day period they are still not restored, you have an automatic provision where the case will be dismissed and the accused is referred to a community service board unless otherwise ordered by the court. And the catch in that is if the prosecutor says this is a case that despite the fact it's nonviolent misdemeanor should not be dismissed, the opportunity is to be brought up in a motion objecting to that by the prosecuting attorney. The rest of the bill is some cleanup language directly from DBHDD that when you first read it, you may say, what are we doing? Because all we're doing, you'll see on lines 147 through 152 is we're pulling that same language down to a new section in 153 to 158. This is where DBHDD uses a vendor to get criminal records for individuals that are applying for jobs with the department. The same paragraph addresses their contractors getting this conviction data, and it's a cleanup requested by the department because there's some confusion with how this is written to make sure that those are separated so we can have the information still obtained for contractors with the department as well. That's all that section is doing. That is the bill, Mr. Chairman. Again, I can dive deeper into it, and there's people that have more expertise than me in the room that could also dive deeper as well.
Yeah, no, thank you for that. So this only applies to non-violent misdemeanor offenses, though, right?
The time period changes too. That's
Yeah.
right. The hearing requirement goes to everyone.
Right. Okay. Yeah, I know my really good friends with our jail administrator out my way, and we have people sitting there waiting for months and months, and not only is there a liability that the jail's assumed for that, but he also wants them to move through the process. So
It's something that makes sense for the people involved that are being accused, but also law enforcement and our courts really want to focus on these more violent cases too,
Right.
honestly. And so I think it's a win for everybody.
right. Thank you for bringing the bill, Representative Silcox.
And I agree with you. I appreciate you, Senator Strickland, bringing this, because we have a lot of people that are repeat 1013s in the hospitals, and they're just filling it up and sitting around. And
Right.
we need to move these people through because we need the space.
Yeah. Thank you.
So thank you for bringing it.
Which one? Holly? Yep.
Thank you, Senator Strickland. This is,
Given the next bill, it seems that way. The two bills I have for y'all today.
but no, I definitely appreciate making that change from that 9 months. You know, it's just exceedingly, you know, it's there. We get it as part of the law, but you know, just for the sake of judicial expedience, to give people, you know, we don't have the mental institutions that we used to have anymore. So we're saddling people who may be ill-prepared to actually to help these folks. And so it's good to be able to recognize they need some assistance before they can even stand trial. This is really necessary. So thank you.
Thank you.
I do have a quick question. Well, two questions. One, I know you said you're striking the 9 month to the 120 days. How will we get? I don't see anywhere in here the 9 month, but I could be completely
Look.
overlooking it.
On page 4,
Okay.
let's see. Online. Let's see. I say page 4.
5, actually.
Page 5.
It's like 105, line 105.
Yes, you found it. It was 108 on my other version. I had the wrong version. I was preparing for today. Yes, line 106. Not to exceed 9 months.
Okay. Got it. Okay.
I buried in there.
And then the nonviolent misdemeanor offenses, is that defined anywhere? What those exactly are? Or is it referencing somewhere where it's defined?
So we have a limitation that we put in on what applies as a nonviolent misdemeanor. I believe that is defined elsewhere.
It's in that 177130, actually. That the same code section is just not in people's bill.
Got a lifeline. Same code section, just not in the actual bill.
The section 2 code section 177130.
I'll let you talk about that in a second. Because no
We
one else
also
can hear.
have a limitation on that. I don't know, and she can clarify if this is in the other section, but lines 87 through 89, we also carved out. And I say we, to be fair, we get credit for these bills. This came from that committee that worked on this.
Right. Okay. Any other questions for the author of the bill? All right, we'll go to witnesses. Okay. Here, Lisa Lynn, you're up.
Jill Travis will join me too.
Thank you. I'm Maisie Lynn Gerton, the Executive Director at the Georgia Association of Criminal Defense Lawyers. I'm joined by Jill Travis, my predecessor Executive Director at the Association and also former Legislative Counsel here at the General Assembly. And really we've just come today to thank Senator Strickland and the others for their partnership in some of the refinement that we've offered and are glad that they agree with it. I've provided a copy to the subcommittee and to the sponsor. If there are any particular questions, we'd be glad to answer those.
We'll do that in a minute. We haven't addressed in the sub yet, so
Okay.
we'll come back to that. Just speak to the bill, and then we'll come back to that.
Sure. So we are one of the stakeholders that agrees that the process that's happening right now is unnecessarily, well, unfortunately, protracted. There are many ways that this could be addressed, not the least of which is resources on the evaluation side, resources on the jail side. There's just a lot to do. But this is definitely a step in the right direction toward allowing an opportunity for a bit more, I'll call it critique on the front end. Ultimately, it's the judge's decision whether to issue the order to get the competency evaluation. And so in cases where, unfortunately, maybe someone brings what you might consider a frivolous request for one, they have the opportunity to deny it. And that's not going to change here. But the language, what is the goal here is to have a bit more of an adversarial process on the front end without, as the chairman said, potentially violating the person who's accused of a crime's right to counsel, their privileged information, and things of that nature in what would otherwise be a public proceeding. So short of the amendments that we're offering, we had really no other commentary on the bill unless you had questions. But to answer your other question, I'm sorry, from before, since we weren't on the mic, the definition of nonviolent offense is in the code section that's referencing it. It's just not part of the bill, 17.7.130.
Thank you for that.
Yeah, it's 130A, nonviolent offense. It's paragraph 7, and then it says it's not a violent offense, and then it defines violent offense. So that's clarified.
Great.
And I don't know if you want us to speak to the reasoning for the amendment.
Not yet. We're not there.
Okay.
Thank you. We'll come back and talk about amendments in a minute.
Okay.
Okay. Anything else?
Good for us? No?
Yep.
Unless you
All
have
right.
questions.
Thank you.
Thank you.
D.A. Cranford?
Mr. Chairman, Herb Cranford, Coweta Circuit DA, Coweta Troop in Meriwether counties. I think, as was previously said, I served on the committee chaired by Judge Goslin. I think she's now retired, but Superior Court judge out of Hall County. Chief Justice Boggs called me and asked me to serve as one of 2 prosecutors on the committee. There were also 2 defense attorneys. I can't remember their names. I know one was a public defender in Hall County with Judge Goslin. One was a private defense attorney in Atlanta, I believe. But the rest of the committee was all judges, Superior Court, State Court, juvenile. I mean, every type of court was represented because the intention was to get the full input of everybody in the judicial system. So I point that out to say, I think this idea was well considered, to Chairman Strickland's point, before it was passed along for his consideration. But one fact I remember that I want to bring to y'all's attention, we were having all these meetings with DBHDD about why is there such a backlog on competency evaluations? Why is it taking so long? The numbers over the years, have skyrocketed in terms of people being ordered for competency evaluation. And that begged the question to me, are there more people who are incompetent now than there used to be, even on a per capita basis? So I asked, how many of those people being referred for competency evaluation come back competent, like in the first instance, as soon as they get evaluated? For felonies, the number is over 70% come back as competent after the initial evaluation. And I think from that discussion was born kind of the idea, maybe we're not addressing this as well as we can on the front end. Maybe there are too many people being referred for evaluation when there is just no, solid legal basis, however you want to put it, And I've had I agree with Gactel that just testified. I think judges currently have the ability to set a hearing to, ask the defense counsel, well, why do you think this person's incompetent? And they could hear that in camera and put it under seal if they wanted. They could ask from the state, well, do y'all have any information that suggests the person is competent? The judges in the committee, in my experience, in talking to other DAs, most of those judges said they're not comfortable questioning that early on. They don't have anything in a statute that they can really feel like they hang their hat on to question this request for an evaluation. And so rather than saying a judge may have a hearing if they want, the judges on our committee, and I totally agree, just saying there has to be a hearing. And we're going to, leave it up to the judge about how in depth do they need to go. They may get some really compelling evidence this person isn't competent and the hearing doesn't need to be too long. I know from preparing for competency trials and things like that, the state often has jail calls and jail messages and detention officers who are having very cogent, lucid conversations with these inmates that are being requested for evaluation. And that might be information that a judge could rely on to say, hey, I get that you may have a little bit of concern, but there's pretty compelling evidence this person knows what they're charged with, all the different competency questions. So that's where we're coming from. I do want to point out nonviolent misdemeanor is defined, but our committee discussed, is there anything we want to exclude from this updated time frame on misdemeanors? And that's why we included the language for excluding DUIs and domestic violence. I think those are the kind of among the most serious cases dealt with in solicitors' offices and state courts and misdemeanors. We handle all our misdemeanors in Meriwether, and those are the cases coming through as misdemeanors that really get a lot of attention. So we didn't want those to be necessarily on the expedited timeline, but happy to take any questions.
Appreciate your testimony. Do we have any questions? Representative Silcox.
I was going to say, to answer some of your questions, I do think we have a growing crisis of Alzheimer's disease nationwide, and Georgia's no exception. If you talk to the Department of Aging, and it's occurring in people younger and younger, and so I don't think it's just a question of old people. I think it really is, like I said, a national crisis. So I think it's critical as this continues to ramp up and our society continues to age that we have a more efficient process. So, and I think this, like you said, by requiring the hearing, then the judges aren't put in that awkward position.
I agree. One final point, if I may. If our office has concern about the person being incompetent, we agree to it, right? So, it's not, prosecutors aren't just unconditionally, uniformly opposing this, but there are situations where we think we have some information that we could give the judge that is relevant,
Great. Any other questions? Thank you so much for your time.
Thank you all.
Come back up here. So, Gackel did provide us with an amendment. Is that a friendly amendment?
So I know that's what subcommittee's for. The only question based on what Mr. Cranford said, and I did not discuss this with you, Maisie Lynn first, is whether on the second line, their proposed language, where it's just the court in its discretion may hold a hearing, if we want to say the court shall hold a hearing. And that would still have the protections built in about the accused not being compelled to testify, present evidence, about the ability to still do ex parte hearings instead. When we presented the bill originally, there's two ways of doing this. You can just say they shall have a hearing and let all that stuff sort out, or you can try to be a little bit more direct about the role of the prosecutor, for example, for the prosecutor side, and for the defense side, to make sure that judges know they can still do things ex parte. They're not going to have the defendant compelled to testify, present evidence. So I think that language may strike that balance if that's what the committee would like to look at. But I'm sure, I'd like, if you would like, Mr. Cranford and also Ms. Gerton to weigh in on that as well. But I don't have a problem with adding some language to try to clarify how the hearing process will work.
Okay. And what I'll do is I'll give some time for Gatcher to come back up, and then DA Cranford to come back up.
Okay.
That's
Thank
good
you.
with But as far as you're right now, we're just,
I'm fine with that.
okay. Come on back up.
I mean, if the only real question is the may or shall, we have no problem with the shall. We were just trying to allow for judicial economy if a judge didn't see the need, but that is completely fine with us.
So we're talking about on where it says insert the following new paragraph after seal on line 32, like really the second sentence after discretion.
Yes, so it would say the court shall, and you would take
That's all
out
that's in
in
its
its
discretion,
discretion
just say
may,
shall, okay.
and just say the court shall hold a hearing.
Have a hold hearing where the prosecuting attorney may submit information regarding the accused's mental competency, to stand trial. The accused shall not be compelled to testify or present evidence, provided, however, that any evidence presented by the accused shall be ex parte, and any evidence submitted by either party shall be filed under seal.
One of the other pieces that we had included, and this is just for clarity, so as you can see, and I don't think we have the right lines, but there's a strike in subsection A in both the sub and the original bill. Yes, probably.
Do you have a current version of
I thought I grabbed one, but now I'm like, oh wait, I do have it. Yep, sorry, yeah. So lines 25 through 27, sorry about that. That is stricken there, but it's brought down. You can see it's kind of like in the last bill in the other part of the bill, you pull that out of 25 through 27 and add a new subsection C. That's the exact same language. Just from a point of clarity, we were suggesting that you also insert after competency at the end of line 39, pursuant to subsection A of this code section, simply because there is language in the rest of this code section that also talks about the court convening the trial. And so in this case, because it was originally an A, it's clearly relevant and related to A, but by pulling it out, which we have no concern about pulling it out, but just wanting to be sure that it still applies here, versus the idea that it might apply somewhere else in the bill. It's just really...
Yeah, we're going to need you to say all that.
Yep, yeah.
So all again for what you're proposing, and then
they have it's so at the bottom.
and then one more second. Yep.
I guess I'm confused. So you want to leave it up above since it, no, you want to take it out?
As far as we're concerned, it could go either way, leaving it above or just clarifying that it applies
So
to
to be
that.
fair, I think that was alleged counsel drafting, so I don't know if there was a reason that was pulled down. But at the same time, saying what she's saying to say pursuant to subsection A would
Just leave it in A. I mean,
that was
same
the
difference.
part.
I mean,
Right,
I'm like,
yeah.
leave it in A. It's clearer to me as far as an amendment.
Agreed.
Okay.
the committee would like, we could give alleged counsel before we go to full committee and ask if there's other reasons to do it differently. That was just a cleanup from them.
Okay.
Yeah, that's all.
All right. We'll just leave it there.
Hard to know.
Go from there.
Okay.
Makes life easier for everybody. Good with that, Brian? Unstrike it. Yeah.
Thank you.
Thank you. D.A. Cranford? Did you have the amendment that you're offering?
I think I'm up to speed on
Here you
it.
go.
Yeah. Thank you. Yeah, and the amendment that would say after line 32, instead of saying in its discretion may, just saying shall. That was the main thing I was concerned about for all the reasons I've already said, and and I think in my experience, sometimes defense counsel ask for a competency evaluation just because they want to make sure they're covered, and having a hearing where a judge says, I don't see any evidence for it, I think will help some defense counsel as well. So I like the idea of just requiring it. I think that is ideal.
Do you have any issues with unstriking 25, 26, and 27 as far as if the court determines?
Yeah, I don't see any. I don't see the difference. Yeah. So. Yeah, I was trying to figure out, is there some implication to that, and couldn't. So.
Okay. Any other questions? Thank you.
All right. Thank you all.
Any more questions for Chairman Strickland? What's the will of the committee? Have a motion to pass. Have a motion to pass in a second. Any amendments?
I guess we have to offer this.
Yeah, or not offer it, either way.
I guess I'll offer the amendment
Okay.
with the amendment in it.
Okay. So what you're asking is after line 32 to add,
The word shall instead of may.
well, it's the whole paragraph, I think, right? So
Correct.
Yeah. So for legislative council, it says provided. So after line 32, after seal on line 32, provided, however, that if a court is presented with information insufficient to raise a bona fide doubt regarding the accused's mental competency to stand trial, the court shall hold a hearing where the prosecuting attorney may submit information regarding the accused's mental competency to stand trial. The accused shall not be compelled to testify or present any evidence, provided, however, that any evidence presented by the accused shall be ex parte, and any evidence submitted by either party shall be filed under seal. That's your amendment.
Correct.
And also striking 25 and 20. Yes, unstriking.
Oh,
So
that's
we'll
correct.
do one amendment. Well, we can do one
Okay.
together. One together amendment. So also striking
Yeah,
Unstriking.
unstriking. Mm-hmm.
line 25, beginning at, if the court determines that it is necessary to have a trial on the issue of competency, the court shall follow the procedure set forth in Code Section 17.7.130.
Which would remove it down below.
That's right.
Mr.
So-
Chairman, and I don't think you said this, but we also need to, in the current bill, strike the changes that exist on 21 through 24.
Come on to the microphone so they hear you too. Sorry.
If you just said this, I'm sorry.
Oh, and I
Madam
just
Chair,
skipped
we're
over it. I was
bouncing around.
focused on the other. You're
I
right.
just want to make sure, so we're striking the additional language that was added with the bill on lines 21 through 24.
Yeah, that's at the top.
And then replacing it with the lines that you read, the new paragraph that you read.
All right. Say that one more time. I'm slow today.
Right, it's 21 through
trust me.
24.
Yeah, I see 21 through 24.
And you see the new language that we just, the original
Provided, however,
amendment.
so it
That's
strikes
what's-
there.
That's
We're
what's
moving our
inserted
old-
there.
Different area.
That's
Moving
what's
our old
inserted
language.
there.
Yeah.
Correct. That's fair.
Okay. All right. So we're striking 21, saying provided, however, that if such information is made known to the court by the accused or the attorney for the accused, a hearing is provided for paragraph 1, subsection B, of Code Section 17.7.130 shall be required.
Right. Right. We'll get it together here.
Okay.
So the sausage is made.
That's right. All right. So we're inserting that paragraph after line 32, after seal, with the shall. We're striking the provided, however, that if such information is made known by the court, by the accused, or the attorney of the accused, a hearing shall be provided. All the way to the end of that sentence required. So that's 21 through 24, and then unstriking line 25, 26, and 27. If the court determines that it's necessary to have a trial on the issue of competency, the court shall follow procedures set forth. Code Section 17.7.130.
And then removing it below. 39 through 40.
Yep. And then also striking line 39 and 40. Section C. Awesome. Okay. Do I have a second for that amendment? Silcox amendment? Second. We have a motion and a second for the amendment. All in favor say aye. Aye. Okay. Amendment passes. All right. So now we have SB 132 as amended with the Silcox amendment. Any further discussion on that? All right. All those in favor say aye. Motion passes. Thank you all so much.
Thank you. Still have this other bill.
Yeah, you still want your other bill, correct?
Sure, if y'all want.
So you want to do it? So Senate Bill 207.
Do y'all have LC 492185?
We do.
Okay, good. That's all I have. Yeah, is it okay
Yes.
if Wade Askew comes and joins me?
You bet.
I got my lawyer here with me on this one, since I don't have a public defender and a prosecutor to help me.
Welcome, Wade. Go ahead and introduce yourself and who you're with.
Hi, Wade Askew, Policy Director at Georgia Justice Project.
So Senate Bill 207 is a 95-page bill, but I've got good news. I can say this definitely with you three. You three voted for this bill already. This is what was Senate Bill 157 became House Bill, was it 808? Am I right on that number? Nobody remembers anyway. Late in session last year, this committee heard 157 last year, and there's just a couple tweaks to it we'll point out to the committee. They're different. But this is the bill that deals with the process of how our occupational licensing boards deal with criminal records. We spent a lot of time in committee last year on this. And 1 in 6 jobs in Georgia require occupational license. The problem is every board treats criminal records differently. And we heard last year in committee individuals, one guy in particular, that talked about the difficulty of even knowing whether or not he could apply for a certain job and go get trained for a certain industry, not having due process built in when a license is denied. So this is a very extensive bill that goes into our boards and goes through each one of them and provides guidance as to how to deal with criminal records. And we can dive deeper into it as much as you guys want, of course, but from a higher level, first thing we're doing is making sure there's a direct relationship between the area you're going to work in and the previous crime. We're defining what crimes are going to be looked at, and then we're saying that you have to have a finding from the board that if you can't work in a certain industry, that your past record has such a relationship to the industry that it makes sense you wouldn't work there. In other words, if you had a DUI 10 years ago, should you be able to go work in a long-term care facility? Probably wouldn't be relevant, but if you have a theft record recently in particular, you probably don't need to be around people that are very vulnerable like that. And so it's that nexus requirement being built in. Second, again, mentioning due process, it creates an appeal process with standard of proof, written findings, an Administrative Procedures Act, administrative hearing, and then appeal if there's a denial of a license as well. Third part is a predetermination process where an individual, before they get training and education, can find out whether or not their past offenses disqualifies them from working in a certain industry. This is the idea, again, of some people aren't going to work in certain industries because they just think they can't. They don't want to go invest the time and money in training and education just be told they can't work in a certain industry. It's also requiring public information on the websites for our licensing boards as to the processes to be followed when it comes to looking at your criminal records. Lastly, we are collecting public data from our licensing boards as to how criminal records are impacting those that are going to work in these industries. I've said this last year, I'll say it again, of all the talk, Governor Deal, all the criminal justice reform work that was done a decade ago, all the talk about how to get people out of our criminal justice system and into being productive members of society, the number one thing is always having a purpose, having a job, having a reason to get up every day, a reason to say no to those people who want to keep you with false promises on the streets and in gangs, for example, a reason to go to work every day and get up and support your family. That's the way you lift people really out of poverty and out of the criminal justice system. And so this bill is something that has a really interesting group of people supporting it, and I say that in a really nice way. You've got groups that aren't always together on issues. Georgia Justice Project has led on the bill and drafting of this bill. We have the Georgia Chamber of Commerce, Metro Chamber of Commerce, the Faith and Freedom Coalition, and others that have all gotten on board. And I won't read them all. Maybe I should.
We have nice logos
Americans for
there.
Prosperity. You'll find groups across the political spectrum that say this is just the right thing to do for people. It's the right thing to do for employers, and it's just the right thing to do for taxpayers in our state too. So there's also some record restriction cleanup that was added in the House last year that you guys, I think in committee, added last year. There was a few little tweaks to that in this bill that I don't know if you want Wade to go over briefly with you. Otherwise, it's the same bill you voted on last year. Happy to go deeper in anything you want to go into.
Correct. Yeah, give us a fairly quick synopsis of the changes.
I can be very quick because they're extremely minor, and we've talked to kind of all the relevant parties to make sure that folks are good. So really the three all have to do with clarity. So when a record is restricted and sealed, there have been questions and inconsistency of, well, if an individual then goes and asks the prosecuting office directly, the clerk said it's restricted, but can I have your file to say, no, that's not really a workaround. So just clarity there. Same for GDC records that are online of who's been in GDC facilities. This came up about a year ago, but what we have now as the cleanup actually is consistent with their current policies. Just again, if there is already a restriction sealing order, what does that mean for them putting stuff online? And then third is around our trafficking survivor statute, the Survivors First Act. We've run into a couple courts, and we reached out to our friends at Street Grace to confirm that they've seen some of the same thing, to ensure the intent that we all think is very clear in the law, that someone, when they make that filing for vacature under the Survivors First Act, the law says it shall be done under seal. We've ran into some inconsistency there where a court has said, yeah, it shall be under seal, but our process to get a seal is you get a court order first. That provision's there to protect people, and so just giving some clarity there that you don't need a court order first, as was intended. And then the second thing is ensuring that everything subsequent to that motion stays under seal, because we've heard people say, well, it says you file under seal. What about the subsequent order motions? Again, we think the intent was very, very clear. This is all to protect people. So it's just clarity around that. That is the only thing that's been added. Otherwise, I think y'all have voted yes on this first 2 years ago unanimously in this committee, then unanimously in this committee again last year, and then on the floor.
I forgot it was twice.
Yeah, so I think y'all have all voted yes on this 3 times. So thank you. And hopefully it got done in the House at about 10:30 at night or so on Sine Die. So that's why we're back. So that's it for me.
The printers get clogged up over in the Senate. Is that what happened?
To be fair on this one, I think it actually was the printers because it was a 90-something page bill.
Those damn printers. We're going to allocate some more money in the Senate for some printers. I know that.
Desk.
A lot of bills died because of them printers.
But we get it out early this time, Mr. Chairman. We won't worry about the printers as much.
Well,
you know?
damn, these printers, I tell you, slow printing over in the Senate. They got like a dinosaur knocking those on the paper. Representative Silcox?
It's a Senate bill. I'm sure the printers will work just fine
Sure.
this year.
Chisel and the stone already working.
No, seriously, this is a great bill. And my question would be, because I know you've said that this is going to take this away from the boards, and my worry would be that there would be confusion on these boards, and hopefully this makes them undo their violent, or their violent offender regulations or what have you, that they're going to change their board policies accordance with the bill, right?
That's certainly the hope, is to give a little bit more scaffolding to
Right.
again say, where do we want our focus to be?
Right.
What's recent, what's relevant, and what's serious?
Right.
And so that's what it's doing. We still want to entrust the boards to make that
Of
determination.
course,
of
to
what's relevant
ultimate
to that. Of
determination,
course.
yes, but this initial.
They need the guidance, and this will help
Right.
give them that
And
guidance.
and there needs to be standardization for sure.
Right.
And then my second thing would be, I know, Wade, that the First Offender Act is your baby too, and I hope this is consistent with that.
It is. So
Okay, great.
Specifically on this, what it says is, while someone is under sentence for the First Offender Act, while you're under sentence, that can be considered by the boards. But if you're successfully discharged, then you're good to move forward.
Great, thank you.
Thank you. Representative Holly?
Thank you, Mr. Chairman. And yeah, thanks for bringing this bill back. It was really sad to see it not cross, but especially certainly for allowing the definition for the covered misdemeanors, because that, we all know, it's 2024. That moral turpitude clause is just, ambiguous, vague, and so if this known by any court in the state that they don't have to follow, that old, revere it, but it's not pertaining to this. It's simply looking at their behaviors within the last, was it 5 years, I believe, for the covered
For the covered misdemeanors.
for the
yes.
covered misdemeanors. So yeah, it just makes it. Thank you for making it even clearer, so that justice can be had. So yeah, thank you. And at the appropriate time, I'd love to put a motion to pass.
All right. Got a couple speakers on it. It's Jeff. Welcome.
Thank you.
State your name and who you're with.
I'm Jeff Thompson. I'm a grassroots engagement director with Americans for Prosperity.
Great.
And thank you for the opportunity to speak today. When I was 19 or 20, I wasn't thinking long term. I made a mistake I didn't realize was a felony. From that point on, every time I filed a job application, it followed me. Even now, it'll still pop up. It's like a reminder I can never fully outrun. And because of that, back then I didn't reach higher. I didn't try for certain careers because I thought, what's the point? I knew the door would be slammed in my face. So, but what about the people who do reach higher and who go to school, who get the training, only to be told when they're finished that their past disqualifies them. These aren't any type of jobs. These are careers that require licenses like electrician, plumbers, barbers, truck drivers, nurses. These are jobs that people turn to when they want to rebuild their life. And if we shut that door on them, what do you expect them to do, or what do we expect them to do? That's why Senate Bill 207 matters. It doesn't erase what happens. It doesn't hand anyone a free license. It just gives people clarity before they waste their time and money. They might never be allowed to have this career, and they've worked hard for it, so it's definitely something I support. It assures that a past mistake doesn't become a permanent sentence when someone has put in the work to move forward. At the end of the day, we all believe in hard work. We all believe in a second chance, and Senate Bill 207 makes that possible. So I urge you to support this bill for me and for countless others who are ready to move forward if they're just given a chance. Thank you.
Well, thank you for your testimony. Thank you for your sharing your story with us and your vulnerability with it.
Thank you.
Appreciate that. Any questions for the witness? Thank you so much. Do we have anyone else signed up? Anyone else out there here to speak to the bill? Great. Okay. What's the will of the committee?
Motion to pass.
Motion to pass. And a second. All in favor, say aye.
Aye.
Any opposed? Congratulations.
Thank you. Appreciate y'all.
Thank you. Thank you for your work. We are dismissed.